Hi everyone. Welcome to our webinar, The Global Struggle for Non-Human Rights. I am Lucia Guy, the co-founder and the managing director of the Institute of Animal Law of Asia, an educational research center that focuses on animal law issues in Asia and the world. At the Institute of Animal Law of Asia, we provide research projects which includes animal law in Asian countries and regions, on topic, on category, and on species animal law articles. This year, we also launched 2021-2022 program, which includes two projects enhancing legal regulations for aquatic animals in Kazakhstan and farmed animal welfare in mainland China. These two projects are supported and sponsored by the Center for Animal Law Studies, Lewis and Clark Law School. We also have the news source Asia Animal Law Bulletin, which includes animal news in Asian countries and regions, the latest updates on the protection of animals, as well as the analysis of the legal issues of the news articles. Last year, we launched the Alliance for Animal Law of Asia, an international networking campaign that aims to cooperate with national, regional, and global animal organizations and aims to improve the awareness of legal protection for animals in Asia and the world. Currently, we have 13 members from across the globe. That includes Europe, Asia, Africa, South America, and North America. If you would like to join the alliance, you can contact us by email ialasia@outlook.com. You can support our work by donating or sharing our website and materials with friends, family, and colleagues. You can learn more about our work on our website, ialasia.org, and find us on social media by searching Animal Law Asia on Facebook, Instagram, Twitter, YouTube, and LinkedIn. This webinar is organized under my project, Enhancing Legal Regulations for Aquatic Animals in Kazakhstan, within the Global Ambassador Program, launched by the Center for Animal Law Studies, Lewis and Clark Law School. This wouldn't have been possible without the CAL support. Our guest today is Kevin Schneider, the Executive Director of the Non-Human Rights Project. He earned his law degree from Florida State University in 2013 with a specialization in environmental and land use law. He also graduated with a BA in political science from the University of Massachusetts, Boston in 2009. In addition to his interest in non-human rights and personhood, Kevin is an advocate for reforming the food system with a focus on plant-based foods. We'll be answering questions after the presentation, so please drop your questions in the Q&A box. Thank you so much for speaking for us today, Kevin, and I'm turning it over to you.
Great, thank you so much. Let me just get my screen up here. Okay. So thank you so much for having me, and I'm going to try my best to fit in the work of the Non-Human Rights Project kind of through the lens of not just animal law in Asia, but specifically, like Lou mentioned, the idea of increasing the regulation or improving the regulation of aquatic animals in Kazakhstan. And while what we're doing can seem like, I think, a world away from that, literally, maybe figuratively, I think that there's a lot of commonalities. So that's one of the things I'd like to talk about, and also just describe the work of the Non-Human Rights Project. So I am Kevin Schneider. I'm the executive director. I'm an attorney as well. I'm based in New York and from the States, and have been working with the NhRP for about 10 years now, starting as a volunteer before law school. So for me, it was, major motivation for me to go to law school was to do this kind of work. And it's fortunate for me, for all of us, I think, that it's now becoming more and more possible to do that. So with no further ado here, I'm going to jump right in. So the Non-Human Rights Project, which hopefully some of you folks have heard of, we're an American nonprofit. We're founded in 1996 by attorney Stephen Wise, who was supposed to be here. He's very sad he couldn't make it here. He had a last minute emergency, so he sends his very warm regards. And so the NhRP, which Steve founded in 1996, after working with the Animal Legal Defense Fund and really being one of the first lawyers in the United States to take on the question of animal law, he founded this organization to secure legally recognized fundamental rights for non-human animals And the three main ways that we work to achieve that goal are litigation, advocacy, and education. Advocacy being legislation. So working through, parliaments and trying to change laws as opposed to going through the courts. But most of what I'm going to be talking about today is that first category of litigation, because that's really kind of the heart and soul of what we do in so many ways. So our mission is to change the legal status of at least some non-human animals from things which lack the capacity to possess any legal right to persons, and I'm using quotes here for good reason, persons who possess such fundamental rights as bodily liberty and integrity, and those other legal rights to which evolving standards of morality and scientific discovery and human experience entitle them. And I'll talk a little bit more about this idea of the difference between a thing and a person. And, while we're talking about mostly Western law and common law specifically that derives from England, these ideas really, I think, are pretty transferable, at least to a certain level, really almost anywhere in the world. And another big thing for us is this distinction between welfare and rights. And we certainly support the work of, welfare organizations. And when I say welfare, what I'm thinking and what I think the common understanding is that you're not really, you're not saying, for example, you can't confine this animal, or you can't use this animal, or you can't kill this animal. The idea with welfare being, we humans do have a right to use you, animal, and we're going to put some rules in place to make that use a little bit nicer. Maybe we can talk a little bit more about the kind of background of welfare, but it really, to sum it up, has, for the hundreds of years that it's been around in the laws, since the 1600s, I believe, the first kind of welfare law that regulated how you could use animals. They've always been very conscious of the fact that their main purpose, yes, you're protecting the animals, but it's really about protecting this idea of the human moral community, and that, we don't want to allow these kind of, bad things to happen, because the main thing is it could impact the human community. Now, that's all well and good, but we are interested in rights. We're interested in something different, more radical, what we think is more of a fundamental change. So this is the difference between saying something like, an elephant can be kept in a zoo as long as you have XYZ, certain amount of hay and a certain amount of water and, certain number of feet of space, meters of space. It goes from that to saying, no, you don't have the right to keep this elephant at all, because this elephant has an independent right to her bodily liberty, which means she either has to be never sent to a zoo or any kind of confinement, or needs to be released either to a sanctuary or to the wild, to any place that's going to maximize her ability to use her bodily integrity, which just means like what we all do, move about in the world freely. Something we can, fortunately, most of us take for granted, but which for non-human animals is basically non-existent for so many of them. So our work really started decades ago. Steve, for many years, was writing law review articles and books and teaching at Harvard and teaching at all these different law schools. Even though it was hard, he would go and say, I want to teach animal rights. And they would say, wait, well, what is that? Even 20, 30 years ago, you can imagine it was even more difficult or strange for a lawyer to do that. But after all this preparation, finally in December of 2013, we filed our first common law habeas corpus petition. And I'll talk a little bit more about what that means, on behalf of a non-human animal. And we say non-human animal to just really remind folks that we too are animals. And so there's really not a good reason to completely differentiate into having rights and not having rights the way that we do. And our first client was Tommy, a chimpanzee we found alone in a cage in a shed on a trailer lot in upstate New York, basically, someone's private property. And our current plaintiffs, so who we're looking at and filing cases for, are members of species who have been scientifically proven to be autonomous. And that's another really key term for us. And right now we know that to include great apes, the 4 species, bonobos, chimpanzees, orangutans, and gorillas, and elephants and cetaceans, so dolphins and whales. Basically, your sea mammals are incredibly intelligent, to the point of what we say autonomous. And when we say autonomous, we really say that, you know, what we mean is that science shows that these beings have a sense of themselves. They have an interest in their own lives. They have, you know, it's not like they're just, you know, running on instinct. They are very much aware. So when you take, for example, a dolphin and put her in a tank, she's very much aware. Science tells us she's aware of the fact that she's confined. She's aware of herself. She's aware of the fact that she can look to a future where she's still going to be stuck there. And we think that's obviously a terrible thing that the law really needs to care about. And that's where habeas corpus comes in, because the point of habeas corpus for the hundreds of years that it's been around has been to protect the liberty of a person. So how do we get that to apply to an elephant or a chimpanzee or any other non-human animal? And here is just a timeline of our cases, but anyone who wants to really dive in, we put everything, all of our papers, all of our, especially for law students or lawyers, I recommend going to our website, nonhumanrights.org, and you can find a complete timeline of all of these cases that we're talking about. So talk a little bit more about habeas corpus, because it is really important for us, and not just because of what it is, but because we think that it's a vehicle that can actually have courts transform a non-human animal from a thing to a person, to essentially say, or at least for the right to liberty, to say that you have this right to liberty just the way that a human being would. So the common law, which I talked about a little bit, is the law that judges make. And so for folks who are have taken some training in this or aware of it, you might know it from torts or certainly contract law. I think torts is like my favorite example of, you know, where you get these interesting common law rules where, you know, it just, there was a certain fact pattern in a case, and like sometimes it's a tricky one, but it leads to this rule. And those are rules that we all have to remember to take a bar exam, but they're also rules that, you know, have oftentimes a lot of sense to them because they come from experience and they come from, you know, the whole idea is of the common law is that it's building on itself, that it's not stuck in place, and that it can evolve. And, you know, it used to be the common law very much, you know, the main engine for the law, but it's been relegated to a little bit of a somewhat lower position because of a lot of statutory law and, you know, administrative law that have kind of crowded out the field. But habeas corpus is one of those areas where the common law is still very much alive and well, at least in some jurisdictions, like the ones that we work in. So yeah, Magna Carta, the habeas corpus began around the time of Magna Carta, so it's quite old. But of course, here's the key thing. So habeas corpus, as we see it, was really created to protect autonomy, your liberty, right? How you're put together, the fact that you desire your freedom and don't want to be confined, that speaks to your autonomy, we think. And so historically, habeas corpus would really just apply to a person. So how would this look in practice? And again, the key word's person, who counts as one? Because when the idea of habeas corpus was really created and put into action, who got to be a person was a very limited set of society, English society at the time, but then to American society and other parts of the world. And so women broadly were not seen as persons. So if a wife was in an abusive relationship, she often had no legal recourse whatsoever. She was essentially seen as the property of her husband. And Black slaves, African slaves were treated brutally as chattel, indigenous peoples. And so, you know, the law, this idea can be really bad. You know, it has a history of being used to discriminate in a pretty awful way. But that being said, it also, and I should also say that, you know, we don't, certainly, you know, we don't necessarily think that these ideas are like the highest expression of morality or anything like that. You know, we're lawyers, and so we take what we have and the pieces that we have and kind of try to creatively stretch it out, because the thinking is that if we present a case to judges that's built from the stuff that they deal with every day and that they were raised and trained with common law and these other principles, autonomy, that we think that makes our case much stronger and harder for them to simply, you know, dispense with or kind of throw away. So while we talk about person, you know, in everyday speech, you would think most often of like you or me, you're a person. But the law is, like with many terms, it has its own special definition when it comes to this word. So really a person just means the capacity for a legal right. And that means, so for a certain entity like a corporation, it can be a person for the right to own property or to bring a lawsuit or to be sued, but it's not a person for the right to marry or the right to drive because, well, it's not relevant. But the key thing there is that a person doesn't need to be biologically alive at all. A person can be kind of basically anything. And one of the really exciting developments happening here is not just with non-human animals becoming persons for certain rights, but also parts of the natural environment. So rivers and mountains and forests are starting to actually get this designation as well, which I think we can talk about a little more, why that's a really important and I think good thing. Yeah, this is basically summing up what I've said. We can now take it for granted, and all the international human rights treaties after the Second World War in particular made it clear that every human being is a person. And that's obviously the way it should be. But there's really no single answer for who gets to be a person and who doesn't get to be a person. It's this kind of really philosophically loaded idea that when you're getting trained in the law, and even when you're practicing law, or even when you're a judge, you really take it for granted because for the most part, you don't have to think about it. You don't have to think about, the law has already come before you, and judges and people before you have laid all this out. And so in some ways that makes what we're trying to do more difficult, but it also gives us a roadmap that we can use to actually try to do it. And so, yeah, this again is just asking the question, a person can have these theoretically infinite number of rights, and a thing, broadly speaking, is incapable of any rights. And so how do we change that? So we build, again, our cases around principles that the judges believe in or claim to believe in. It's a funny thing when you actually put this in argument in front of a judge, you might get some sympathy, or you might get them to react in a very strong way, which I don't have a ton of time to talk about, but in other talks we've done, we actually go into detail into some of what the exact, language that judges have used against us. And it's interesting to look at, to see psychologically, why they react, why they feel maybe threatened by this idea. But again, we go to this idea of autonomy, why we always hammer back to that, because it is a value that's in the law already. So again, we're not, while in our hearts and minds, we might think, this is self-evident. How can you keep an elephant alone on 1 acre, or, do these terrible things? But the fact of the matter is, as with many things, even human slavery or these other awful things, you would think that just being bad would be enough to get people to realize that and change, that it's immoral. But unfortunately, the world doesn't seem to work like that yet. If it could, but so we have to, as with previous, social change, litigation, and campaigns, you really do, I think, have to use some of the building blocks, even if you're trying to not so much dismantle them, but fundamentally change them in some way. And so autonomy, we make that case using affidavits from some of the greatest scientists in the world. So for chimpanzees, we had Jane Goodall and many others. And for elephants, we have people like Joyce Poole and Cynthia Moss. And they give in great detail a description of not just the behavior of these non-human animals, but the kind of cutting edge science about the cognition of what goes on inside their brains, and how similar they are to us in these fundamental ways. In particular, desiring to have their own lives and their own families and their own cultures and their own freedom, really. And so we point out to the courts that, science now in this day and age has shown beyond doubt that we're not the only species who fit this bill of autonomous, which can be can seem like a sort of a squishy standard, but, it is pretty well documented in the scientific literature and somewhat in the law too. And we think that, obviously looking at the cases that have come down over the years, that autonomy is really important. at least for humans. And judges have shown a willingness to really go out of their way to protect the autonomy of an individual person, even if it creates a really big inconvenience. And that's kind of the idea. It's sort of, if you're familiar with utilitarianism, this idea of autonomy is kind of the antithesis of that. You're sort of saying, well, it doesn't matter what benefit, like the community might get from this, what's happening here. If it's doing a terrible injustice to the individual, then we really can't, the law can't allow that. At least that's what we argue. And this is really important for us too, is that we argue that autonomy is sufficient, but not necessary. And I think that's important because we would never want to be seen to be foreclosing other arguments that could be, for other species who aren't necessarily autonomous, or at least the science maybe isn't there yet. Although I happen to think personally that as science kind of continues, we will just see more and more species who actually are shown to fit this bill of autonomous. But nonetheless, we don't argue it's not necessary. It's not, it's sufficient. And specifically for this idea of habeas corpus, because we think since habeas corpus protects autonomy, it sure seems relevant that, we're talking about species who have been shown to have autonomy. So there's a match there between how they're created and what they need, and what the law claims to protect. So these are two of our clients in New York, Hercules and Leo. They were actually the first to get a hearing. So the way it works with habeas corpus, even in a human prisoner context or any context, you file the petition basically saying who you are and where you're locked up, and making an argument for why you shouldn't be locked up. And that goes to a judge, and they're supposed to review it like very quickly. That's one of the things about it that we like, is that it's supposed to move, at least in theory, pretty quickly. And then they have to make a decision. Are we going to give you a hearing or not? Do we think there's some merit to your argument, or is it pretty clear that you should be locked up for one reason or another? And for the first time in Hercules and Leo's case, we convinced the court to actually grant us that hearing, which was a pretty transformational thing. And for anyone who wants to, you can see pretty much all of it. There's a documentary film about us that's on HBO and other places, came out a few years ago. It's called Unlocking the Cage. So you can see, among other things, the full argument, which is pretty fascinating. Here are some pictures from it. And that's Steve there on the right, standing up with the white hair. And the other fellow standing up is actually an assistant attorney general in New York, because Hercules and Leo were being used by a state university for research experiments. They were represented by the attorney general of New York, which we think was a really good thing for getting the case to be, taken up and taken seriously, but also to get a lot of media to look at it and to use that as we hope, teaching tool, which is a big part of what we do. And so after all the arguments, unfortunately, for a reason of a pre-existing precedent in another case, which we might not have time to get into too much, but this trial judge, Barbara Jaffe, she said, isn't it incumbent on the judiciary to at least consider whether a class of beings might be granted a right or something short of the right under the habeas corpus law? So, she was sympathetic, but ultimately she had to rule against us on the grounds that, a previous court in another one of our cases said that you can't have any legal rights whatsoever, including habeas corpus, if you are the type of being who can't take on duties and responsibilities. And this is a really roundabout way of the court saying basically only human beings can have rights. Broadly, they weren't even talking about habeas corpus, they're talking broadly. So obviously that's not a good ruling for us, but we think it's not a surprise. No one has really asked this question for hundreds and hundreds of years. Does the law have to be this way? So it's really not a surprise, looking at history and other examples of trying to change the law. It doesn't usually happen right away. You have to kind of chip away at it. And Hercules and Leo, they had quite the saga. They were sent back to the lab where they were born, and then they were since sent to a sanctuary in Georgia, which sounds great, but there's some issues with the sanctuary. it just really goes to show, like many of our clients, how vulnerable you are when you have no rights whatsoever. You can be moved around. You are property. You know, you can look at the way that zoos, you can get some of the sheets that they actually trade animals. They say, we'll give you an elephant for 2 walruses, or, you know, it's like they're just like Pokemon or something, and they're just being shuttled around the country or the world. And that's what we point to as a main consequence of being a thing, of being property, essentially, in this way. And Tommy and Kiko, I'll try to run through quick here so we have time for any questions. But again, their cases are featured in the documentary film as well. And again, this is the case that I mentioned where you get this duties and responsibilities standard. And Kiko, another chimpanzee, upstate New York, a former actor, who was partially deaf from past abuse on the set of a film. The court in his case ruled that it wasn't appropriate to send him to sanctuary because it was not seeking immediate release, which is another kind of interesting issue. And then fast forward a little bit, this was a real kind of turning point for our cases in New York and really around the country and the world. This was the first time where a sitting judge on a high court, so the Court of Appeals in New York is the highest court. There's 3 levels. And in 2018, we had filed our second or third attempt to get up. It's kind of like the US Supreme Court. They can pick and choose which cases they're going to take, and they don't take most of them. They only take like 5% of them. So we had tried a few times. And on the third time, we didn't get the hearing, but we did get this judge to stick his neck out essentially for the first time and say some pretty remarkable things. So I won't read through all of it. I encourage anyone who's interested to read it because it's really a pretty stirring thing if you do this work. So he got the fundamental question, right? Can a being who's so remarkably like us and what we now know about their cognition, like a chimpanzee, can they be released from confinement through habeas corpus? And should such a being be treated as a person or as property, in essence, a thing? And he went on to say, much like we would say that being a moral agent who can freely choose to act as morality requires is not a necessary condition of being a moral patient who can be wronged and who may have a right to redress wrongs. That's a really kind of complicated way of saying basically that this whole duties and responsibilities idea is wrong. It's not a good reason to deny relief to these chimpanzees, among other reasons, because we wouldn't use it as a reason to deny relief to a human being who didn't fit this, who didn't have the ability to take on a legal duty. Because children, someone in a coma, someone with Alzheimer's, someone with any type of, all kinds of different conditions, they don't have legal capacity. I mean, everyone talks about Britney Spears. She's treated now as not having full legal capacity. But that doesn't mean that she doesn't have other rights, right? So it's an example of a judge here really sticking his neck out, and while he couldn't give us the full relief because he was just one judge, he nonetheless wrote this 7-page concurring opinion. And he said, he pointed out here that that the reactions of the other courts were essentially speciesism. That's what he's talking about here, I think, when he says that the appellate division's conclusion that a chimpanzee cannot be considered a person and is not entitled to habeas relief is in fact based on nothing more than the premise that a chimpanzee is not a member of the human species. And for some people, that they might say, well, duh, that's what the law is for, to protect humans. But here's a judge who's I think really getting it, that's not the only thing that the law cares about. And in particular, this part of the law can and really should evolve. And he says here below, in elevating our species, we should not lower the status of other highly intelligent species. I would say we shouldn't lower the status of any species, but at least this is a judge saying this. And then he goes on to recite some of the facts that I was talking about from the affidavits and from Jane Goodall, and really the fact that chimpanzees can make tools and recognize themselves in mirrors and television images, imitate others, exhibit compassion and depression. You know, a lot of these same traits apply to elephants and to other non-human animals. I know that dolphins and whales also fit this bill in terms of being able to imitate and to recognize themselves, to even, you know, name themselves and have aspects of culture. So we see a lot of, you know, autonomy is something that is not confined to any one species. It's not confined to humans. It's not confined to elephants. It's not entirely clear where it comes from and why. And, you know, is it, you know, we look at things like the, you know, anatomy of the brain and the chemistry of the brain, and you know, the affidavits look at that level of detail. But nonetheless, we argue that this autonomy exists, and so you courts have to take it seriously. And this is just one of the, this is a really good amicus brief that was written on behalf of our case and that was turned into a book. So if anyone's really interested in the sort of philosophical dimensions of all of this, I definitely recommend that. And yeah, I won't read this whole thing, but just to point out here that, again, you have the judge talking about whether a chimpanzee is an individual with inherent value. And again, that's sort of another way of saying a person, or anti-utilitarian, like you have this inherent value for whatever reason, your dignity or your autonomy, or just because you're a human or whatever it might be. That's what we're talking about when we talk about rights. And so Judge Fahey, he finished his concurring opinion by saying there's no doubt that a chimpanzee is not merely a thing. So we're like, okay, we're onto something here. This is good. That was 2018. So we've continued to, like with any kind of long-term case like this, you take the decisions or different building blocks you're able to get and build them into the next case. So this was in Connecticut. All the cases I was talking about before have been in New York. And Connecticut has been a tough state for us. I won't say a whole lot on it right now, other than that we brought a petition, actually 2 petitions for these 3 elephants in a traveling circus. Sadly, 2 of them have died during the time that since we filed the suit because of, well, the way they're treated. They're basically worked to death. And the courts in Connecticut, for one reason or another, have just not shown anything like the openness or the willingness of the New York courts to look at this question. So for the time being, we're kind of not working in Connecticut, but we're always, you know, looking if there's an opening for us. But meanwhile, back in New York, after Judge Fahey's opinion, we filed our first case, I should say our case on behalf of Happy, not our first elephant case, but Happy was the first elephant to pass what's called the mirror self-recognition test, which is kind of a classic marker of self-awareness. Even in, you know, human child psychology, it's used as a test to see basically, you know, when a child gets to that point when they are self-aware. And while it may seem simple, you know, you can see the way this test is done, that they put a mark on the elephant or the dolphin or different species without them knowing it, and then put them in front of a mirror. And if they, you know, start looking in the mirror and touching their bodies, like, you know, like you might do if you saw something on your head, that, while it seems very simple, is actually incredibly complicated, because it takes a whole lot of mental activity and machinery to hold this image and actually realize that it's you, and you know, tie all this together. So while it may seem kind of simple, it's actually really foundational to even a lot of what we consider to be our intelligence and autonomy and sense of self. So Happy's, you know, case has been really quite huge, and it's been going on for, you know, I said these habeas corpus cases are good because they're quick, but what isn't so quick is when you go up on appeal. And so we're continuing to litigate her case. She's now back in the Court of Appeals. We're literally waiting any day now to find out if they will decide to take her case, which we're really hoping that would be the first time that we got a high court to actually, you know, grant our appeal, which we think would be a really big deal. It would bring in all kinds of, you know, attention, but also, you know, we can sense that the zoo industry and, you know, the gun industry, all these different industries we don't even talk about, they're watching us because I think they're afraid. And, that makes me very happy because I think that means that we're doing something right. And so Happy's case, I had to include this. This is what the director of the Bronx Zoo said on TV that when we filed the suit, literally like our papers are like this big, and he filed this on the same day. I don't think he read it, but I think he, have the knee-jerk reaction that we're making, misstatements about their staff or alleging that they're being cruel to her. We're not. This is not about anyone at the zoo. This is not even about the zoo. We don't, there's no allegation of a welfare problem, but that's the issue, is that Happy has been on, 1 acre, which is like a backyard, for 40 years, and she's been alone for 15 years. And the fact that that's totally legal, I think makes the point that at least for some species, welfare is completely insufficient. And for Happy, for an elephant, she fits that bill because it has nothing to do with how she's treated. They could be giving her a bath in gold every day and, doing her feet and giving her, she still is not able to exercise her autonomy. She still is deprived of this fundamental right. And so for us, that's really all we care about. And that's all that, a habeas corpus case is about. But we think that this kind of, reaction really, again, means that we're hitting a nerve. So I won't talk too much about this, but we also are working on a legislative approach to this issue as well, which would seek basically the same result. So, for example, in a city, to have them recognize the rights of a certain species, and they would potentially have to close a zoo exhibit or otherwise make a tangible physical change to respect the rights of a non-human animal, or one or more. And here's again the film I mentioned, Unlocking the Cage, and it's just a part of our broader education work, which is things like this, webinars or law review articles or media, anything that we can do to not just educate judges, but the broader public to begin to. And I think over the last 5 years, we have seen news stories that are more respectful. It used to be when we first started, you would get a lot of jokes. You would say, "Oh, this is about Planet of the Apes. They want the chimpanzees to drive. They want chimpanzees to get married." You see all these kind of jokes, or maybe just people are uncomfortable, so they say these kind of things. But we've seen that change to a point where it's a much more respectful coverage of it, and I think that makes a big difference because the judges read this stuff too, and we think that has a real impact on them. And also we're getting more and more active outside of the country, usually just kind of lending our support or sharing our research, or otherwise supporting what folks do. And what's really exciting is that, everything I've been talking about, habeas corpus for animals, while we're you might say struggling here in the US, I think we're doing okay, but it is a bit of a struggle. In other countries, you've already had judges grant similar relief. So in Argentina in 2016, a court declared in response to a habeas corpus petition that a chimpanzee named Cecilia was a non-human legal person, and she was sent to a sanctuary in Brazil. In India, the Supreme Court apparently recognized the personhood of all animals in the country, although it's a little bit tricky to understand exactly what that means just because it's so broad. But it is, nonetheless important. And in Colombia, the Constitutional Court, they actually were considering it a habeas corpus appeal for Chucho. That was denied, unfortunately, but Chucho, the bear, had won a habeas petition in a lower court, and then it went all the way up to the Constitutional Court, where we actually just got it translated into English, and you can read, there's a very long dissenting opinion that, while we're still trying to figure out exactly what it means, it talks about, our cases, it talks about habeas corpus, it talks about why Chucho should have been given the right. So this is, again, kind of like Judge Fahey, when you have dissenting opinions, that's a really important kind of first step to changing parts of the law. Oftentimes, you can see this kind of repeat itself over and over through history of dissents and other things kind of paving the way for eventual decisions. And like I mentioned before, this idea of personhood is not confined, to non-human animals and to, advocacy on their behalf. You're also seeing it in the environmental sphere, which I think is a really cool thing. And so I'm pretty sure this is my last slide, which just I think a really appropriate and touching quote from Jane Goodall, who's actually one of our board members and has been for a long time, and obviously a hero to so many of us. And I think she says it perfectly. How should we relate to beings who look into mirrors and see themselves as individuals, who mourn companions and may die of grief, who have a consciousness of self? Don't they deserve to be treated with the same sort of consideration we accord to other highly sensitive beings ourselves? So this is, I think, where I wrap up. And again, you can find us at nonhumanrights.org. You can encourage everyone to join our email list. And you can find us on social media at Non-Human Rights or Non-Human Rights Project. We have a couple different ones, but and that's my email there. So thank you, and I'm happy to take any questions.
Thank you so much, Kevin, for this wonderful presentation. We can move on to our questions. First question is, how to respond when it is criticized to be speciesism to protect chimpanzees or gorillas for animal rights?
It's funny, because just having gone through, we get that sometimes, and I can understand it, but it's funny because we have people on one side saying that, why are you focusing on these human-like beings? And on the other side, we have judges in court saying, there's no way any animal, I don't care, any animal's crossing that boundary. So we are, and I think this is kind of a good thing in the sense that what we're trying to do is really big, and it might not be personally always the kind of arguments we would make, but we're trying to accomplish this larger goal and kind of really kick down a door to get judges to start thinking about this. And it's our strategy, it's our kind of take that they're most likely to do this when they're, working off principles that they already know about or claim to care about, like autonomy, and where we're not really asking them to reinvent the wheel so much as to sort of expand it a little bit. And I think that I just think that that's important. I think that while it would be more in line with how I feel, and I think most of us feel personally, talk about if any animal can feel pain, that should be enough. But we live in a world that's a lot more complicated than that, and where animals are killed in the trillions every year. And so I think we need to start at a more realistic starting point. And again, that's not to shut off any other avenue of doing this. I think there's real strength in diversity of approaches, and the other good thing is that if once it starts to get taken up as a legislative question, which it is beginning to, then it's a much more open playing field, because a legislature can use any kind of grounds to make rights. But since we're in court, we have to be a lot more kind of strategic about it.
Yeah. Our next question is, what would you suggest on elevating legal status of animals in countries where animal law is non-existent? Where to start?
So I think there's a couple, again, the welfare type of work is always, I think, important, because you have to, if you can improve the lives of animals, even while they're being used, even if you can't dismantle an entire system in the process, I think that's important. But I also tend to think, and I think there's some evidence for this, that depending on which country you're in, there might be some opportunities to almost skip over, the leapfrog over what some Western countries have done, and maybe even if it starts as a symbolic kind of thing, do something bolder, kind of skip over So for example, in Latin American countries and other countries too, this is starting to spread, the idea of rights of nature. And some, in a lot of countries where you're seeing it, they didn't have, like we do, this really complicated idea of environmental law and regulation, which is actually kind of a problematic thing in a lot of ways. And so while it remains to be seen how it will work, I am a kind of a believer that you can, when you're starting in a place where it feels like you have like nothing, or it feels that way, I think you can be a little more creative almost, because you don't have the same kind of baggage. Like when we're in court, judges have, they are used to thinking about animals through a welfare perspective. So we have to sometimes struggle to really get them not to fall into that trap, and to realize that we're asking them to actually create something different. So that's an example of how I think almost having too much law can be a problem too.
So in those countries where animal law is non-existent, or animal welfare acts exist but not enforced, you suggest to start with animal welfare approach?
I think it depends on which, so if you have an industry where, say for example, food, that I think where it does call for welfare as a starting point. But if there's an opportunity, for example, to maybe someone, you pass almost like what would you call it? A proactive law, I guess, where you would say, well, we don't have any dolphinariums in the country now, but we're going to ban them so that it never happens. Sometimes I've seen you can make some headway in a smaller country, or a place where it just hasn't been thought of that much. Sometimes it's because a legislator might want to make like a splash and be seen as someone who's done this interesting thing. And if that's what it takes sometimes, then I think that's a good thing. But also, yeah, I think that, welfare, it's important, but I think it's also important to have people trying to push out the boundaries as much as possible too, and make judges a little uncomfortable. I mean, that's a big part of what we do. Is we aren't here to make them comfortable. We're here to put them on the spot. And yeah.
Okay. Next question is, what is your next animal to work on granting legal rights? Are you working only in the US, or you're planning to expand your work in other countries?
Yeah, so we've been for years working with lawyers in other countries. And it's starting to pick up, I think. In Latin America, I mentioned there's a lot of work being done around rights of nature, but also more specifically around habeas corpus for animals. So we're now working on amicus briefs that will go to the Constitutional Court in Ecuador. They're right now considering the question of whether non-human animals can have rights, and whether the rights of nature grants them any rights, which we're going to have to figure out. It's a very complicated thing. But we're also working to help lawyers essentially replicate what we've done in other countries where they use habeas corpus. We think it seems like it's been working in Argentina and some other countries. So we're hoping to continue pushing that along. And so dolphins, whales, orcas, for quite some time, we've wanted to bring a case against SeaWorld for one or more orcas. The problem has been that there isn't a sanctuary to put them. And so we can't file a lawsuit until there is one. So that's been the main hurdle there. And then other great apes, we are always considering as well. But we also, when we're asked by folks in other countries who might want to do this, we think there's potential for this to expand in the near future to other species, but a lot of that will entail having the scientific support. So we need to make sure that we have scientific affidavits that we feel really do prove, if we're doing a habeas case, that the individual is autonomous, that they fit that description.
Okay, thank you. Um, how does non-human rights project initially pick animals for the legal personhood work? What do you usually rely on?
So it really has been driven by science and this idea again of autonomy. And so Steve actually did some work with Peter Singer and others on the Great Ape Project before leaving that and founding what became the Non-Human Rights Project. And so there's, I think, understandably, because we know so much about great apes and they are so much like us, um, there's been so much work over the decades. There's so much to work with there in terms of science that it's made it somewhat easier because of people like, particularly Jane Goodall, starting that process and convincing the scientific world to view them in that way. And so, yeah, really, that's the main driver. And then, being lawyers, it can be tricky, especially with something like a case like this, where you have to be in the right jurisdiction and you have to find the right plaintiff. There's so many kind of factors that, what kind of judge is it going to go in front of if you file in this place versus this place. So those kind of considerations come up too, because, we truly do see the individuals we take on as clients. And so we want to do everything possible to achieve this right for them and protect this right, while also being aware that the cases that we're doing can have an impact in a bigger way on other species, other animal cases, other jurisdictions. So it's a balance of what is the strongest scientific case, but also the facts of the individual case. Do we think they're going to be legally strong for us?
Next question is, hi Kevin, I remember talking with you at the Animal Law Conference in 2019 in Portland about pursuing cases for dolphins in California. What is the status for those cases?
So again, the dolphin, it's mostly a matter of not having sanctuary for them, but we are quite close to filing our first California case. Will likely be on behalf of an elephant, in part because we have the affidavits already, but we are working on dolphin and orca affidavits so that hopefully before too long we have the sanctuary and we have the facts ready to go. And one of the great things about the cases that we do argue is that we've created a template with our chimpanzee cases that can really be used for other species as well, because the fundamental ideas are the same. You're talking about an autonomous being who should have a right to liberty, and it just so happens that they might be a different species from case to case. But so I'm hopeful that it will become sort of easier as we move ahead to continue to add other species and claims to our work.
Mhm. The next question is, are the concepts of animal rights and animal welfare and their difference relevant for the argument against habeas petitions for non-humans? Do they augment or reduce the strength of the argument?
So I think that it's central to it, and because to be able to have receive a writ of habeas corpus and to actually be freed, you have to be seen as the type of being that has a right to liberty. And again, looking at Happy's case as an example, I think is a really good one, because she currently doesn't have this right to liberty, even though the trial court that we were in front of, she heard us for 13 hours, which was really incredible. She had us back for 3 days. This was in the Bronx in New York. And she took us very seriously. She heard us out, and she ultimately ruled. She was very sympathetic. You can read her opinion. It seems that she wanted to rule for us, but again, you have the appellate courts that have come before that have said duties and responsibilities. So she was, really stuck with that. But nonetheless, you can see that we really made an impact. And I think very convincingly made the case that welfare for being like happy is not enough. And I think, again, that doesn't mean it's not necessarily an either or, because there might be some species now or some situations where the problem is just too big to think about rights right now. I think if you're talking about, for example, a chicken in the United States being raised for food, I mean, there's so many issues there that you would have to fight through. But when it comes to an individual like Happy and the claim that we're making, even though we're asking them to really make this radical change and grant her rights for the first time, because that's the other thing is that I think in culture, it's kind of like the word person. We use it a lot. It has a meaning for, you might talk to someone and a lot of people believe that animals have rights now, but the fact is they don't. Not in this country, and really not meaningfully in any country yet, although it's starting to happen. And so it can be, and there definitely is some gray area, right? They do kind of melt together in some instances, like the kind of life that we think Happy should have at a sanctuary would be a high welfare life, right? But it's, for us, it's a little tricky sometimes, but the key thing is her autonomy being respected, is her liberty being respected. And what we think that means in practice is how much space does she have? How much ability does she have to get away from others? And how much ability does she have to interact with other elephants if she wants to? We think all of that stuff is relevant, but it really can only be considered in a really durable way if they have rights. Because the other thing is that, if you just have a change in the law, that could be taken away. But if you recognize a right in this way, which I think is what makes some courts nervous or makes our adversaries really nervous, is that once you establish a precedent like this, I think it'll have a much kind of stronger impact, and it can't just be done away with quite as easily as maybe as a welfare law could.
We have a few more questions for you. Hi, Kevin. I work in the area of animal welfare. I've met some animal rights advocates who are against the concept of animal welfare. How should I respond to them? Thank you.
Well, yeah, it's really tricky. And like, frankly, honestly, I know people who are in the movement who, frankly, they're more extreme than I am, and in terms of their thinking. And I think it comes down to, and I can identify with that because in my earlier days, I might have been more that way. But I think maybe you just sort of experience or whatever you feel you just have to kind of deal with the reality as it is. And that's not going to satisfy most people who think this way. And I guess for me, I've just kind of come around to that we're not going to satisfy everybody, and that's okay. You just can't do that anyway. And this is a debate that's been going on, I think, for a long time, takes on different names of liberation or abolitionism. And I mean, I'm just of the opinion that realistically, if you're dealing with a giant issue like food, I guess my main takeaway for when people bring this up is that there are a million different species of animals, and there's so many that are in different conditions or relations to us. So there's no one size fits all. And that's not really going to satisfy everybody or maybe anybody, but I think that's kind of what I typically try to say.
Yeah, that's very true. You can't please everybody.
Mm-hmm.
Next question is, how can one work or volunteer in animal rights law in the United States? Any particular organizations like the Non-Human Rights Projects that can take in non-experienced people to assist with daily operations and research?
Well, we do have, we're always happy to get inquiries. So we have a volunteer at Non-Human Rights email address. So you can, contact us there. We would be happy to hear from you. And otherwise, I would say just kind of keep your eyes open. I learned about the Non-Human Rights Project myself 10 or 12 years ago for the first time. And then I was inspired and got involved, and now I'm here. So there's that's one way for people who really want to make like a life and career out of it. But at the same time, us and others are always open to getting these kind of inquiries from folks.
Yeah, I would personally add like meeting new people, networking from the same community. That would definitely help too. We have our last question. In the past, the Non-Human Rights Project has researched judges and venues as a strategy to try to get the best case outcomes. That has shown to have unpredictable results. Is the organization still using this strategy, or is that no longer considered potentially viable? And other states beyond California that your organization may pursue for dolphins and orcas, do you foresee any cases in Oregon for any species?
So the first one, yeah, we have kind of. I think that it's more relevant to talk about or to research a jurisdiction. We used to think back in the days that you could sort of pick your judge or research your judge or like have an idea, like read their mind or how they're going to rule on your case. I think we're all pretty much, now that we've done this for a pretty good amount of time, we've kind of given up on that idea. Like you really can't guess. So Judge Fahey, for particular, is like a 70-year-old white Republican. You wouldn't necessarily think that that would be the first person. We've had female judges who have been brutal to us, just terrible, like really unfair. And then female judges who have been great to us. So, and people of different races. So I think that it's really hard to guess what a judge is going to do. So we've kind of, and in a major way, it's in most instances it doesn't really matter because it's a random draw anyway. You can't really pick your judge. So that, but in terms of the jurisdictions, I think that is still relevant because, again, while Connecticut is an example of where we thought that based on the law, mostly, looking at precedents in the state, different things that they would be more open. Turns out that they weren't. But New York, I think for all of the sort of challenges that we've gone through, has still been a really good state for us. Not just because we've gotten these incremental, steps along the way to actually winning a case, but also because of the fact that it's New York. I think it has an impact on other, judges in other states and other countries, and we've seen our cases cited approvingly in, Indian cases and Latin American cases. So that seems to be evidence that, New York was a pretty good idea. In California, we think oftentimes people ask us, why haven't you gone to California yet? And and that's what we're doing, and we'll see how that goes. And we have some indications that they will be more open to us than your average state. Steve was actually invited to speak to their Supreme Court a few years ago, so that was an indication to us, like, oh, maybe you guys are open-minded to this, as opposed to, for example, like Mississippi. We just don't think right now there are many judges in Mississippi that are going to take our case seriously. That could be totally wrong, and I think we're always, open-minded to different things. But by and large, you can make these kind of assumptions. And what it also really comes down to is our resources. These are very intensive, time-intensive, resource-intensive cases. So when we go into a state, we have to be really prepared to fight it out. So it's a big investment of time and resources. But in terms of other states, Oregon's a place we've looked at for quite some time. It just hasn't come together yet for a couple of different sort of technical reasons, but mostly, again, like resource reasons. But Colorado is another place that we're close to filing, and again, in other countries. And also, we're getting to a point where we've created attention around the issue, which helps to hopefully start to see lawmakers actually take it up and start to essentially do the work for us, which has always been part of, I think, the larger plan, because we can't just go from state to state to state and every individual and just file everyone get an individual case. I think the hope is that over time it really kind of takes on a life of its own, but it also is a way of guiding legislation that actually creates rights and not just welfare.
Okay, and that's all for questions. Thank you so much, Kevin, for this very interesting presentation, and thank you so much for all your questions. The recording will be available on our website, ilasia.org, and on social media. You can find us by searching iAnimal Asia. Also, check out the website of the Non-Human Rights Project, nonhumanrights.org, and have a nice day.
Thank you.
Thank you. Bye.